After years of trying to pack the Supreme Court, there's a new attempt to take control of the third branch of government. Rather than placing extra justices on the court, all of which would be appointed by the current president, of course, they want to set term limits for and a complicated method of appointing justices. Now, is any of this constitutional? How will Congress and the courts react to this abuse of power? Will the American people meekly sit back and watch while the Constitution is once again set aside by Congress for political ends? And what would happen to America if this legislation is allowed to see the light of day? We'll discuss all that next, right here on the Constitution Study. Hello there, everyday Americans, and welcome to the Constitution Study. My name is Paul Engel. I'm glad you've joined us here today. We're going to be talking about some new legislation, but I want to remind you, you can find all of my previous episodes, all the written articles at constitutionstudy.com. It's a great resource for you to find information, to ask me questions, to find out about the events we're putting on. It's all there, and I'll talk a bit more about it at the end of the program. But now I want to talk about this legislation. Term limits in general are a controversial subject. Many believe that allowing people to remain in an office for extended periods of time is detrimental to the republic, while others value the experience that comes with time and service. Still, when it comes to offices created by the Constitution of the United States, is legislation all that's required to establish term limits? A brief look at our history should prove the answer. After serving 2 terms, Franklin D. Roosevelt told the Democratic Convention that he would only run if drafted. Now, Roosevelt won the nomination on the first ballot, then won a decisive victory over Wendell Willkie, becoming the only president to serve more than 8 years in office. Now, term limits became an issue during Roosevelt's 1944 campaign against Thomas Dewey. As Dewey put it, 4 terms or 16 years is the most dangerous threat to our freedom ever proposed. Though he won the 1944 election, President Roosevelt died just 82 days after his 4th inauguration on April 12, 1945. However, after the midterm elections in 1946, Republicans took control of both the House of Representatives and the Senate by campaigning on the issue of presidential term limits. Now, to fulfill their election promise, Congress did not simply offer legislation, but a resolution to amend the Constitution itself. The language that was sent to the states became the 22nd Amendment. No person shall be elected to the office of the president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of the president more than once. Why was it necessary for Congress to propose a constitutional amendment to impose term limits on the president? Because the language of the Constitution does not place a limit on the number of terms a president. Now, since only laws of the United States made pursuant to the Constitution can be valid, the only way to impose term limits on the president was by an amendment. Now, the first problem with H.R. 5140 is the fact that it violates the supreme law of the land. This act may be cited as the Supreme Court Term Limits and Regular Appointments Act of 2021. Congress does not have the legal authority to set term limits on the Supreme Court of the United States. Congress can determine the number of justices primarily by the advice and consent of the Senate, but there's nothing in the Constitution that allows Congress to set term limits or to force a justice to step down except via the impeachment process that requires the bad actions of the justice. The judges of both the Supreme and Inferior Court shall hold their offices during good behavior. Now, this legislation starts by establishing a schedule for appointing justices to the Supreme Court. The president shall, during the first and third years, after a year in which there is a presidential election, nominate and, by and with the advice and consent of the Senate, appoint 1 justice of the Supreme Court. Now, right off the bat, we run into several problems. First, Congress does not have the legal authority to force the president to nominate federal justices. While the president is required to execute the laws of the United States, that does not include when they infringe on the powers delegated to him by the Constitution. Article 2 of the Constitution says, he shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur, and he shall nominate and, by and with the advice and consent, shall appoint ambassadors, other public ministers and councils, judges of the Supreme Court. The second problem this section of the legislation creates is too many justices. Congress has placed a limit on the number of justices at 9. The Supreme Court of the United States shall consist of a Chief Justice of the United States and 8 Associate Justices, any 6 of whom shall constitute a quorum. So how would Congress deal with this particular problem? Well, by effectively replacing all of the justices. In general, except as provided in subsection C, the panel of justices exercising judicial power in cases and controversies shall comprise the 9 most junior justices. Deemed retired. After a justice has served 18 years, that justice shall be deemed a justice retired from regular active service under section 371B. Exception: no justice appointed before the date of enactment of this act shall be counted toward the panel of 9 justices described in subsection A, nor shall they be required to retire from regular active service under subsection B. So Congress plans to simply put out to pasture the most senior justices as they add new ones? Did you notice this panel of 9 justices are not exercising powers of the Supreme Court, but judicial powers in general? Furthermore, subsection C says that the current justices are not counted toward the panel of 9 justices who are actually to exercise the judicial power. Does that mean they are immediately removed from the court, even if they've served less than 18 years? It does say they will not be required to retire, but they cannot serve on the panel. So what would they be doing? Also, since the currently sitting justices could not be on this panel, does that mean we effectively start with 1 justice on the Supreme Court and wait for years for more to be appointed? If the Senate does not exercise its advice and consent authority with respect to the President's nominee to the Supreme Court within 120 days after the nomination, the Senate shall be deemed to have waived its advice and consent authority with respect to such nominee, and the nominee shall be seated as a justice of the Supreme Court. So H.R. 5140 wants to put a 120-day time limit on the Senate's advice and consent rule. But what defines the Senate exercising its authority to advice and consent? Would the Senate Majority Leader, after advising the President that the Senate is not going to hear nominations, be exercising its advice authority? Would there have to be a vote? Isn't this infringing on the authority of the Senate itself to set their own rules for their own proceedings? Isn't this infringing on the authority of the Senate to set their own rules for their own proceedings? Each house may determine the rules of its proceedings. And since the Constitution doesn't set a time limit as to how long the Senate has to advise and consent on a nomination, isn't this legislation simply superseding the Constitution, or at least attempting to? As another insult to the Constitution, this legislation would create a new type of justice called a senior justice. Just what would the senior justice do? Any Chief Justice of the United States or Associate Justice of the Supreme Court who has retired from regular service under Section 371B of this title shall be known and designated as a senior justice and may continue to perform such judicial duties as such justice is willing and able to undertake when designated and assigned by the Chief Justice of the United States. I'm not sure quite what to call this. Semi-retirement? This does, however, give us a clue as to what the legislation is all about and what the ultimate goal of the sponsors are. See, while the official title of this legislation is the Supreme Court Term Limits and Regular Appointments Act of 2021, it should be called the Reinvent the Federal Judiciary Act. Not only is Congress claiming the authority to change the duration of a justice's service, but also how and when they are appointed, and by creating a post-court position that they may fill. Now, whether you think there should be term limits for justices on the Supreme Court or federal justices in general, it cannot legally be done by simple legislation. What these congressmen want to do requires an amendment to the Constitution. If there's one thing that has become obvious, it's that Congress has become disconnected from the Constitution, their oaths of office, and any semblance of the rule of law. If you support the Constitution and want representatives who do the same, then you must contact your representative and senators to either demand that this legislation be turned into a proposal for a constitutional amendment or simply discard it on the ash heap of history. If Congress can reshape the judiciary by simply passing legislation, why not change the entire government? Why bother with a constitutional convention? Let's just let Congress recreate the United States in its own image. Wouldn't that be awful? When I first heard about this legislation, I thought it was a simple term limits issue. When I read the legislation, I found it was so much more. This act is an abomination to the Constitution. It's Congress placing itself above the supreme law of the land, claiming the authority to reconstruct different branches of government, all on their own. This is not a constitutional republic. The question is, what will we the people do about it? Now, hopefully I've given you some information and you can reach out to your representative and your senator and help put a stop to this abomination. But in the long run, it's going to take more than that. It's going to take knowing what the Constitution says. As John Jay said, it's going to take every member of the state diligently reading and studying the Constitution of his country and teaching the rising generation to be free. Now, if you want to do that, we can help. We can start with constitutionstudy.com. You can find the articles, the videos. You can ask questions. I love when people ask questions. I'll even answer them on my radio program if you'd like to listen there. You can join us on our tour. I'm going to be traveling the country this year. I'm going to be traveling the country later this year, reading and teaching the Constitution. Find out more at constitutionstudy.com/tour. Now, if you'd like to become a student, a scholar of the Constitution, well, I've got a place for you too. Just go to constitutionscholars.com and you'll find a group of scholars that are reading and studying the Constitution and teaching each other to be free. You can even join my mentoring program and become a better student and eventually a teacher of the Constitution. Just check it all out at constitutionscholars.com. The important thing is we the people must be engaged. The preamble of the Constitution says we the people ordained and established the Constitution. We did it through our states. And it's about time we stop simply waiting for someone else to actually apply the Constitution. It's not the words on parchment that will run this country. It's the people we hire to fill those offices. And lately we've done a pretty poor job of it. But we can change that. And it starts with education. So please join me as we read and study and learn more about the Constitution and what it means to be citizens in this great republic. Better yet, why don't you find a few friends and family and bring them along next time for the Constitution Study.